Good morning. Thank you very much for joining me on this video. I want to talk to you this morning about non-conforming dwellings. When you enter into an agreement of purchase and sale to purchase a property, certainly in the province of Ontario, the chances are you're going to use an area form, and it's going to have something that we call a requisition date and a requisition period. What that says is, and it's usually clause 8 on the agreement of purchase and sale, it says that the lawyer will have till such and such a time to examine the property title and make sure its current use may lawfully be continued. And then it goes on with clause 9, and it says, and further, there's no warranty or representation that any other use is permitted except what is stated. And this is very important because when you buy a property, you're buying bricks and mortar, you're buying the land, but you're also buying the use or the bundle of rights. Let's talk about a triplex, for example. I'll use that as the illustration. If you're buying a triplex, yeah, you're buying the bricks and mortar, but you're also buying the potential revenue stream. And the potential revenue stream depends on whether you can continue to rent out 3 different apartments. And so it's important. So when you fill out that requisition period and you fill out its present use, you need to be careful about how you fill it in. It isn't enough to just put residential. The lawyer's going to look at that and he's going to search title to see if it can lawfully be continued. Well, residential just means you can dwell in it. It doesn't tell him whether it's a duplex, a triplex, a single family home. You could put multi-family residential, yes, but then if it's a duplex and not legally a triplex, but it's functioning as a triplex, once again, the lawyer won't pick up on that. So be specific when you say it's present use, notify the lawyer, and then the lawyer is going to, the first thing he's going to do is he's going to check the zoning to see if it's compliant with the zoning. When I say that, I want you to be aware that if it conforms to the zoning, that doesn't guarantee that it's legal. And if it doesn't conform to the zoning, it doesn't guarantee that it's not legal. It's a starting point. But let's talk about that for a minute. If it conforms to zoning, let's suppose the zoning is R2. And R2 permits triplex in this particular case, and you're buying a triplex, then that's fine. That's great. It conforms to zoning. That's huge. But he doesn't stop there, or you shouldn't stop there. You need to contact the municipality and find out how they show on their records the property registered as. Is it a duplex? Is it a triplex? Is it a single family residence? And that's what's legal, quite apart from the zoning. You see, within each municipal jurisdiction, there are also not only zoning, there are also bylaws. And within any given zone, there's bylaws that have to be met in order for a property to be legal. When you're dealing with a rental property, a duplex or a triplex, there's minimum square footage, there's parking, there's side yard, there's setback, there's all kinds of things in the bylaws. And it may well be that the property conforms to zoning, but doesn't meet the bylaws. And you have a problem if it's registered as a single family or a duplex and it's functioning as a triplex, because now in order for it to be legal, it has to conform to the bylaws of today. And that may be very difficult to bring about. I think you'll find with triplex especially, there's an awful lot of properties that are legal duplexes where somebody's added a 3rd apartment and they've never checked with the municipality, they never got a building permit, they never got consent for it to be a triplex. So it's a legal duplex, it's an illegal triplex. You can make it legal, but to make it legal, you have to conform to the current bylaws, or you have to get a minor variance. For example, if there isn't enough frontage, you may be able to get a minor variance where they will allow it and make it legal even though it doesn't conform. But if you don't do that, it's technically not a legal triplex. Now, having said that, most municipalities are reactive, they're not proactive. What I mean by that is they're not out looking for trouble, especially when it comes to residential dwellings, because they realize there's a scarcity of them. But if they get a complaint, they have to act on it. If you have a triplex in a zone that's duplex, but there's multiple families around, the chances of somebody complaining are very, very minimal. You can probably operate it as a triplex year after year after year. But understand, if somebody does complain, the city has no choice but to enforce the bylaws. All right, well, you say, well, I know properties that absolutely don't conform to even zoning, and yet they continue on and seem to be legal, change hands and everything. Yeah, it can be legal. And there's a principle that if a municipality changes the official plan, changes the zoning, or changes the bylaws, and it takes a property that was legal and now makes it illegal, it can't take away its previous use. They call that legal non-conforming. So the most municipalities throughout the province of Ontario in 2013 did a radical readjustment of their official plans, changed zoning, changed bylaws, and so on. And in addition to that, each municipality revises their bylaws and revises their zoning probably half a dozen to a dozen times a year. So there's all kinds of changes, and it's quite possible that the property you're looking at doesn't now conform, but can be legal non-conforming. How do you make it legal non-conforming? Well, that can be a little bit tricky. What you've got to do is find out when the particular bylaw or zoning change occurred. So in other words, maybe you have to go all the way back to 1971. There were a lot of changes made that year. And maybe the property was a legal entity prior to 1971, but not after that. What you have to do is you have to establish that it was in fact, in our illustration, a triplex prior to 1971. How do you do that? Well, if you can search back and find out who owned it then, and they're still alive, get a letter from them. Doesn't have to be notarized, doesn't have to be an official document. Get a letter from them stating, yes, I owned this property in 1968 and I operated it as a triplex. That's good enough. Can't find them, find a neighbor who was living there back in 68, 69, prior to 71. Get them to write a letter saying, yes, Bob and Sue Jones owned this property back then and they operated it as a triplex. That's fine. You can't find these people, go to the library and search the archives and find either a newspaper or a Vernon or Cross directory and check back prior to the date and see if the roll shows it as a 3 people occupying it, and that's proof enough. Once you've got that proof, you take it to your municipality, show it to them, and get them to change their records so that they show that it is now a legal non-conforming. One more thing about legal non-conforming, it has to be continuous use. If you have a convenience store and it's zoned now residential, but the convenience store predated the zoning change, you have to show that it continued to be a convenience store. If they changed it to an apartment at some point in time, a duplex or apartment, somebody wants to change it back to a convenience store, you've lost that legal non-conforming use. It has to be continuous use. Having said continuous use, let's suppose you have a duplex, and I know several examples like this, where the owners owned it for years, they've tired of having a tenant, and they've left the apartment there, but they just haven't bothered to get a new tenant in there. That doesn't lose its non-conforming status because it's continued to be a duplex, just an unoccupied duplex. And of course, you could have any situation where a tenant leaves and it takes you a month or 6 weeks or 2 months to find an adequate tenant, and that doesn't lose your non-conforming status. And similarly, 3 months or 5 months or 2 years, as long as it stays that configuration. But if you make it part of the house and you rip out the separate entrance and you change the modification of the kitchen and so on and so forth, you'll lose that status. So it's important to understand the status of all these things. Why am I bringing all this up? Because when you buy a property or when you in turn want to sell the property, you have, as I said, the bricks and mortar, but you also have the use of the property, and you want to make sure that you understand what you're buying and you can rely on that use moving on into the future. Hope that makes sense. I want to thank you very much. Look forward to talking to you again next week.